My name's Herb Fishbarker. I'm the head of the Workplace Relations team, and I will be your host today. So I won't be presenting, but I'll be hosting, so I've been relegated. Today, we're excited to present our webinar preparing for the 2025 federal election. Over the next 60 minutes or so, we're going to be, well, first of all, exploring what proposed workplace relations reforms have been identified by the major political parties and their likely impact on both the employment laws and workplace practices across Australia. Two, we're going to dissect a recent Fair Work Commission full bench decision that dealt with the very important issue of the use of individual flexibility arrangements by staff, or IFAs as they're commonly known, and the common pitfalls that employers face in responding to an IFA request. And then finally, we're going to provide you an action plan to assist you in focusing on those HR aspects of your business that need to be addressed post the election. A couple of housekeeping matters. As I've indicated, that we're hoping the session will be confined to around 60 minutes, or we'll make sure it is. There will be some Q&A time at the end of that. We'd ask that you hold off any questions to the end of the presentation. But do feel free to submit questions through the chat box function as you think of them through the chat box function. We'll seek to respond to those at the end of the presentation. Okay, the important stuff. Well, first of all, I'd like to introduce you to our presenters today. First of all, James Sanders, my fellow principal in our workplace relations team. Jennifer Song, an associate within our team, and Karina Ha, who is also a lawyer in our workplace relations team. Without further ado, please welcome each of the presenters in providing their presentations. First of all, handing across to James. Thank you.
Thank you, Herb. Good afternoon, everybody. Thank you very much for attending today. As Herb said, my name's James Sanders. I'm one of the principals here at MST in our employment law team. Having a look at the attendee list, I think I've spoken to most, if not all of you before, so I should be a friendly face, but for those of you I haven't, it's nice to see you here. I've got the honour today of talking about the Labor Party's proposed policies, and also I'm going to touch on the Greens policies for reasons that will become obvious later in my presentation. But I thought today we should start off with what the Labor government has achieved through the past 3 years, as that will determine or dictate exactly what it is that they are doing if they are successful in achieving a re-election. So as you can see, they introduced a large number of workplace relation reforms over the past 3 years. There was some 7 amending bills that changed the Fair Work Act, or supporting legislation around employees and employers. Some of the big ones that you'll have remembered: the abolition of all of the pre-2010 enterprise agreements or collective agreements, the outlawing of pay secrecy, limiting of the use of fixed-term employment, and also what I think are 2 very controversial changes because they simply create ambiguity within the employment and engagement relationship, and that is the variation of the definition of casual to be one that is relationship based, and also the effective overturning of the contractor versus employee decisions of the High Court. Both of these have created, in my view, grey areas or ambiguity in which employers are left at a loss as to what they have actually engaged or employed, and there are risks to employers as a result. And Jennifer will touch on a couple of those later when she's presenting. And the one that everyone remembers, the most recent one, and the one that is still due to come in August for small business, is the right to disconnect, this right that employees have to no longer be contacted unreasonably outside of working hours. Can we go next slide, please, Dina? So it's no surprise then that with all of those changes, and Tony Burke being the minister who made all of those changes, with the change to the new workplace relations minister, Mr. Watt, it's no surprise that the Labor Party has taken a fairly quiet approach to this election in terms of industrial relations. They have put forward two quite large policies that are going to cause some changes, and that is it. That is the policies that they are running on. The last time a party took a very quiet approach to IR, as they are, was when the Liberal Party last won an election. You may recall the government of the time, or the Liberal Party of the time, went in with no IR policies, and they were successful, whereas the Labor Party went in with 30 or 40 policies and were unsuccessful. So I'll talk about those two policies today. I will also touch on a couple of sleeper policies, ones that haven't necessarily made it to the forefront of the Labor Party's policy booklet, but we need to consider because they're likely to come up again this next term if re-elected. Could we go next slide, please, Dina? So the first one we're going to touch on, you will have all heard at the budget when released, was the removal or restriction of non-compete clauses for people who are earning below the high income threshold. The current high income threshold, $175,000, excluding superannuation. Now, we currently have no knowledge as to how this is going to be implemented. We are still very sparse on the facts. But what we do know is that it's expected to come in 2027, should the Labor Party be successful. It is going to be limited at this stage to non-compete clauses. And what we can surmise, or if we crystal ball it slightly, we can expect it to be introduced in a similar way to the pay secrecy clauses and the use of fixed term contracts. And that is, if it is in place at the time the law changes, those clauses will simply be read as null and void and won't apply to those individuals. And if we have a contract or an employment agreement that is entered into that is non-compliant after the date of introduction, we can probably expect penalties to be applicable for a breach of the Act. Now, a reminder, penalties under the Act are not to be sniffed at. For businesses, it's $99,000 per contravention at this time. That generally goes up each year. And it's also $19,800 for an individual who is actively involved in the contravention. So if this is successful and if it does get through and if it ultimately does come into effect in the same way as those pay secrecy clauses, you as employers are going to need to review your employment agreements to make sure you don't put yourself at risk of a penalty being applied simply by an administrative mistake. And that is presenting an employment agreement to an employee under the high income threshold, because that's what your template provides. There are also a number of other matters you will need to consider should this come in. Do you employ someone at, say, 170,000, which is what the market says, or do you bump them up to 175,000 to allow you to enact this non-compete clause? The biggest question we got when this was first announced out of the budget was, does that mean ultimately I'm lost as an employer? I've got this risk sitting over me with employees who are going to run off to competitors and divulge all of my information. And the simple fact is no. There are still going to be protections for employers. You'll still have confidential information protections. You will still have the Corporations Act protections on employees using information that came into their knowledge whilst they're employed by you. But it will just mean they get to go to a competitor. So you'll want to also look at how you employ these people. And quite frankly, what notice period do they have? You could introduce a pseudo non-compete clause by taking the minimum notice period under the Act and increasing it. Put in a 3-month notice period clause, and then you buy yourself effectively a 3-month non-compete by putting that person on garden leave. They will sit at home, they will do the gardening, they can't go and work for your competitor, they can't work in the industry, they have no contact with your clients, and ultimately you're buying yourself that protection. So should the Labor Party be successful and this does get implemented in 2027, there are a number of steps you can take to continue the protection that you otherwise would have been afforded. Next slide, please, Dana. The second policy that the Labor government is taking, or Labor Party, I should say, is taking to this election, and only came out in the middle of last month, was protecting penalty rates. The ARA has made an application to the Fair Work Commission to introduce exemptions for the General Retail Industry Award, which effectively state an employee could be paid a higher base rate of pay and avoid their penalty rates. This isn't new. This has been done in enterprise agreements for years. And in fact, some awards like the Restaurant Industry Award at certain levels allow for this. But rather than risking it, the Labor Party has indicated that if they get into power, they will legislate to stop any penalty rates being reduced. Now, this is a very odd decision by the Labor Party, in my view, simply because the Fair Work Commission is to be seen as an independent tribunal. They are to make decisions on wages and the awards based on submissions given by opposing parties, and ultimately they'll come up with the outcome. To prevent the Fair Work Commission from making a decision that reduces penalty rates simply leaves them in a position where they could only ever increase penalty rates. And it would allow for applicants, taking unions as an example, to apply to increase penalty rates without risk of the Commission ultimately reducing those penalty rates if the submissions go against them. So if this was to be legislated, it's quite likely we could see a number of applications to modern awards to increase penalty rates. Now, overall, in the short term for employers, this doesn't mean a lot. We have a current application to the Commission to pay 18-year-olds adult rates in sub-modern awards, but penalty rates, there are no substantive applications to increase penalty rates. So in the short term, nothing's going to change, but it doesn't mean that those applications won't come. The one thing you could look to do to protect yourself from those increasing penalty rates, and as much as enterprise agreements for small businesses who operate under one modern award aren't that beneficial anymore, they're not as beneficial as they used to be, you may choose to implement an enterprise agreement to lock in those penalty rates. You'd effectively be photocopying the modern award that applies to your business, implementing that enterprise agreement, and because of the way the Fair Work Act is drafted, if there are no further changes to the Act, you would lock those penalty rates in and avoid those risks. So a number of things to think about, but one thing that you do need to be aware of is if they do make those applications, the Fair Work Commission's not great at advertising them, and so you'll need to keep across modern awards and any increases to penalty rates, which of course we will keep you up to date with. Next slide, please, Dina. Now that I've talked about the two big changes that the Labor Party has actively said they're going to look at if they are successful, we'll get on to a couple of the sleeper policies. And those are policies that have previously been raised, but not necessarily actioned in this term of government. The first one is superannuation. We all know we've got a 12% superannuation change coming in 1 July this year. That is the last of the ongoing superannuation increases. But one change that was first discussed by the Labor Party in 2023 was to have superannuation paid on payday. It's called payday superannuation. And that is when you pay your staff, you would also be required to pay their superannuation within 7 days, whether that's weekly, fortnightly, monthly, whatever pay cycle you use, as opposed to the current quarterly that you can access as an employer. Now, whilst this was a sleeper policy from 2023 onwards, as of March, they did finally introduce some draft legislation for consultation. And it was ultimately as expected. Payment would be on payday. If the Labor Party is successful on Saturday, we can expect that this will be pushed forward and it will be a change that will come in. Now, it's not slated to come until 1 July 2026. So you do have some time to get your procedures in place, get your policies changed, make sure your administrative actions are up to date, and importantly, keep an eye on that cash flow. Because any time that you are spending money that comes out of your business, it's money you haven't got to use elsewhere. And whilst superannuation should be quarantined and paid quarterly currently, cash flow of business often is such that you will pay that superannuation quarterly. You're now going to have that money on hand at the time you pay your wages to pay what is now a 12% amount on top. The only big risk to employers here, other than possible cash flow issues, is that the more often you pay an item, so more often you have to pay wages, more often you have to pay superannuation, the more chance you've got of making an administrative error. And if you make an administrative error on superannuation, immediately you've got the superannuation charge you've got to think about. So that will come into play. And as long as we've got good policies and procedures in place, we're going to avoid that. But it's something you're going to need to keep across. 1 July next year, I don't see there being any leeway 1 July will be the firm date, and you'll need to be ready to go at that time. If not, you're going to be at risk. And finally, the last sleeper cell or last sleeper policy for the Labor Party that again was talked about in 2023 and it committed to in 2023 was a national labour hire licensing scheme. No further steps have been taken on that in terms of implementing it. We currently have 4 states or territories that have slightly different labour hire licensing schemes in place. And for those of you that work in the labour hire industry, I expect this is something that we will hear more of over the course of the next 3 years if the Labor Party is successful. I don't actually see this as a negative. We currently have labour hire clients who work across borders of states. There is confusion about which scheme applies. If they're in a state that has no licensing requirement, do they have to get one to place people in other states? If they work in a state that has a license and they place people into another state with another licensing scheme, do they have to get 2 licenses? At the end of the day, realistically, this is a money grab by the federal government. The state governments all currently run their licensing schemes. I would expect to see this one come in. It will create uniformity. It will reduce the difficulty of operating state to state for labour hire providers, but also reduces the risks for people who use labour hire providers. You will be able to safely use your labour hire provider that you are comfortable with in any state or territory in the country, knowing that they are a licensed labour hire provider in each state and territory, rather than having to pick and choose based on states. So I don't see this as a negative. It is just going to be an additional cost that you're going to need to think of if it is implemented at some point in the Labor Party's next term. I mentioned earlier that I'd also be touching on Greens policies. The Greens Party and the Labor Party are quite hand in hand and have been for a number of years. And in fact, a number of the policies implemented by the Labor Party in this term ultimately originated as Greens policies. So it would be remiss of us not to look at Greens policies for this election as something that the Labor Party may introduce in the course of a successful re-election. You can see there on the slide some of the big ones that were ultimately or originally Greens policies that were supported and put forward by the Labor government. The 2 that obviously stand out, the banning of pay secrecy clauses and also the right to disconnect. Both originally Greens policies, both supported by Labor and both introduced in the most recent or the current term of the government. So for that reason, we need to look at the Greens policies moving forward. The 3 that I'm going to touch on are up there on the slide: 4-day working week, paid leave for casuals, and superannuation for under 18-year-olds. 4-day working week isn't anything new. We've seen 4-day working weeks talked about, and in fact, enterprise agreements have been drafted for big businesses around the possibility of a 4-day working week. Modern awards, actually a lot of them, allow for a 4-day working week by extending the day's length. Employees do more hours on less days. They have a 3-day weekend. That's not what the Greens Party is advocating for. They are advocating for a reduction in the employees' hours to 80% of their hours, going down to 4 days per week, but being paid 100% of their wage. They are going to support test cases through the Commission to see how this changes productivity of employees with reduced hours, but same pay. Whilst I don't expect this policy on its own to ultimately succeed, it is the starting point of a defined towards 4-day working week. But there are some obvious concerns or obvious risks here that need to be considered in more detail. The first is superannuation. Superannuation is only paid on ordinary hours, not on overtime. So if employees are only working 4 days a week, there's quite possible that their superannuation amount will reduce when employers start considering, well, what am I going to pay people when they're working 4 days a week? There's the obvious additional overtime that may need to be worked and the lack of employees we currently have in this country. The most common complaint I get from clients is, I can't find staff to fill the positions. If we were to go to a 4-day working week, you would have to have employees doing a lot more overtime, or you would have to have a lot more employees. Because as a society, we're not a 4-day society. We are now 7 days realistically. We want everything open. We want everything available 7 days. We want our coffees on the weekend. We want to be able to go to the post office. We want to do everything we can 7 days a week. And if ultimately it's reduced to a 4-day working week, people are going to be working longer hours of overtime, or we're going to need more people to do those jobs. They're also advocating for paid leave for casuals. This also isn't new. The Victorian government, you recall, in 2022 ran a 2-year pilot program to pay sick leave to employee or casual employees in certain industries. For a number of reasons, that hasn't succeeded. Pessimists amongst us might say it's because the Victorian Labor government spent all their money elsewhere and they couldn't afford to keep the pilot program running. But the fact is it didn't succeed and didn't proceed any further. But the Greens are advocating for paid leave for casuals. They've not provided any detail around how this would be paid for, how this would be worked out, whether there'd be a reduction in the casual penalty rate, casual loading, or if casuals would continue to receive the 25% that they do and paid leave. If you to do a bit of a calculation, paid sick leave or personal leave and paid annual leave, if someone was to take them throughout the year in their entirety, it equates to about a 14% lift on the employee's wages, if you were to average that out. If there was no reduction in the casual loading, ultimately you would be paying more for having that employee and they get their paid sick leave and annual leave. This could simply be a drive towards permanent employment, a view to get people out of casual employment because it's going to cost them the same or more than it is permanent. So drive people to permanent. You'll have seen the amending acts at the start of my presentation. The changes are all in the titles: secure jobs, better pay, protecting worker entitlements, and closing loopholes. It's simply a push towards permanent employment, and this may be that. And this is one that the Labor Party may look at jumping on to continue to drive that position. So it's one we need to keep an eye on that quite possibly will be implemented. And the last one for me today, superannuation for 18-year-olds. We currently pay superannuation to under 18-year-olds who work 30 or more hours a week, and that is it. It's limited there. This is, in my view, a very easy change for the Labor government to implement, and it's a very easy change for them to implement when they look to bring in payday superannuation in 2026. As I've said earlier, we have no increase to superannuation percentage as of next year. That finishes this year. The easy selling point will be there is no superannuation increase. We are going to payday super, and we need more employees to have more superannuation at the end of their life, so that we're going to require superannuation to be paid earlier to allow for the compounding effect. This is, of the 3 Greens policies, the one I expect will be introduced in the course of a re-elected Labor government. And so we need to keep an eye on this one. So overall, I think there's a couple of policies in the Greens that we need to keep an eye on, and this superannuation one with payday super is one I expect a cost for employers to go up in the middle of next year. That's my portion of the presentation done. I'm now going to hand over to Jennifer Sung, who is going to take you through the Liberal Party's policies. Thank you, Jennifer.
Thanks, James. So my name's Jennifer, and I am an associate in the employment law team here at MST. It goes without saying that the opposition holds a slightly different view to the Labors and the Greens in its industrial relations agenda. During the election campaign, the Liberal Party's policies on industrial relations and policies have taken a bit of a backseat compared to other hot topics that we see all the time in media. However, there are a number of policies that the Liberal Party have either pledged to implement under a coalition government throughout the past few years and otherwise form part of its general messaging and rhetoric in opposition to the Labor-backed industrial relations reforms. So on the slide are a few of these proposed reforms that I will now go through if coalition government comes into power. As James had mentioned earlier, the right to disconnect was introduced by the Labor government as part of its Closing Loopholes Act. The laws took effect from the 26th of August of last year, and that only applied, or it commenced taking effect for non-small business employers, and it is legislated to take effect for small business employers from 26th of August this year. As it currently stands, employees have the right to refuse contact from their employer or from a third party, such as a client or customer, outside of their working hours, unless that refusal is unreasonable. If we take a bit of a step back and look at the rationale of the right to disconnect, the rationale put forward by the Labor government was that the right to disconnect would protect employees from being unreasonably required to perform unpaid work after their usual working hours. This would significantly decrease unpaid overtime, especially in light of the increasingly blurred lines between work and home life. Ever since the right to disconnect was first introduced and passed in Parliament as in the Closing Loopholes Act, Peter Dutton had promised that this right to disconnect would be repealed under a coalition government. Some have described the introduction of the right to disconnect as a bit of a non-event, especially because of all the hype and the attention and the build-up by the media after the new laws were first enacted. But what we've seen is that our employer clients have successfully navigated the change and the introduction of the right to disconnect by having contracts reviewed, by implementing new workplace policies. So on the ground, the real life impact of the right didn't quite eventuate as media would have reported. If the right is repealed, then it is more likely than not that, for the most part, a similar thing would happen on the ground. The real life impact of the right being repealed will not be that significant for employers and employees alike. However, from a legal perspective, the right to disconnect will no longer be a workplace right protected under the Fair Work Act. As of last month, 7 cases had been brought forward through the Fair Work Commission, which involved the right to disconnect. 4 out of these 7 cases are reported to have been made under adverse action and unfair dismissal laws. If the right to disconnect is repealed, of course, it doesn't mean that we suddenly don't see any adverse action or unfair dismissal claims, but it does mean that there is one less item to be concerned about, especially in cases where employees make a kitchen sink claim where they put claims that all of these workplace rights have been exercised and they've been dismissed, for example, for those rights. In general, it does increase operational freedom if the right to disconnect is repealed and reduces the risk of disputes on the right to disconnect, whether an employee's refusal was of contact was reasonable or not. Where existing policies have been implemented, then employers now, or once the right to disconnect is repealed, they would have the freedom to decide for themselves whether or not to maintain or change or abolish these types of policies. Because even where the right to disconnect is not a legal right under the Fair Work Act, employers can still implement policies surrounding overtime or policies surrounding employees being on call. All of these matters may be relevant to the business, to employees' own health and safety within the workplace, and may touch upon those policies that an employer may want to implement to promote workplace health and safety. The next thing that I will be talking about is the definition of casual employees. The Liberal Party has been very vocal about this one as well. They have vowed to overturn Labor's definition of the casual employee, which was introduced in the Closing Loopholes Act. The current definition is that an employee is a casual employee if the relationship has no firm advance commitment to ongoing work. Now, in determining whether there is a firm advance commitment, as James had referred to this earlier in the presentation, we would have to look at the real substance, the practical reality, and the true nature of the relationship. The closing loopholes definition is Labor's change to the first statutory definition of casual employee, which was originally introduced by the Morrison government. So that definition, rather than looking at the relationship as a whole, it focuses on whether at the time an offer is being made, whether the employer makes no firm advance commitment to ongoing work to that particular employee, and whether the employee accepts that offer on that basis. So the main difference here is that the Liberals want to return to this contract-centric definition where we more or less focus only on the contract at the time the offer was made to the casual employee, whereas the current definition, we would have to look at all sorts of factors to determine whether an employee is casual or not. By returning to a contract-centric definition, this would provide greater certainty for employers and employees alike. And it furthers the Liberal Party's belief in individual freedom and free enterprise, and in their words, to promote the autonomy of an individual to contract freely with their employer. The Liberals have also promised sweeping reforms to crack down on alleged corruption and organised crime within the building and construction industry. This is one of the more prominent policies that they've highlighted in their campaign. It is in response to the latest revelations about the CFMEU's links with bikies and organised crime. And part of the proposed action involves reinstating the Australian Building and Construction Commission. This commission was abolished by the Albanese government in 2023. And Liberals' view is that abolishing the commission has resulted in the construction industry being less regulated. Because after the commission was abolished, the FERC Ombudsman was handed the responsibility of overseeing and enforcing compliance across the building and construction industry. But of course, the FERC Ombudsman also has that responsibility across many other industries as well. The coalition government and Liberals, they have stated that if the commission is reinstated, the commission will have increased powers compared to those that the FERC Ombudsman currently have. They'll be able to enforce compliance of the FERC Act and other regulations. And there will also be increased penalties for breaches of the FERC Act. So this is something that employers, especially within the construction industry, should keep an eye out for. Another measure proposed to stamp out lawlessness in the construction industry is to immediately deregister the construction division of the CFMEU. As we know, the latest allegations about CFMEU and its links, there are varying schools of thought on what deregistering the CFMEU will practically achieve and how employers and employees will be affected. Our view is that employers would experience less union pressure from the CFMEU, who, as we all know, are quite a strong union. But employers will also face the uncertainty of what will happen next, because once the CFMEU is deregistered, it doesn't stop them from still operating effectively as a union and engaging with its union members without regulation or oversight. Legally speaking, once the CFMEU is deregistered, it will no longer have official standing as a union. This would limit their rights to organise industrial action or represent members in disputes or even enter work sites. But like I said, and this is also part of the Albanese government or the Labor Party's criticism of the proposal, is that we don't know what will actually happen to the union and whether it would be returned back to its criminal elements. The last slide and policy that I will touch on is in relation to hiring apprentices. The Liberal Party have proposed a $12,000 wage support payment for hiring apprentices in small and medium businesses. And there is an emphasis on housing and construction trades where they have specified there will be a priority for those apprentices being given that wage incentive. Based on the Liberal statistics, Australia has seen a 30% drop in new starts for construction trades in just 3 years. So the aim of the wage incentive is to see an increase of the number of apprentices, but more so to create, quote unquote, a future-ready workforce. So again, any employers within the construction industry in particular, but also the wage incentive might extend to other industries as well, should keep an eye on this policy in the event that it does eventuate, and there might be benefits in hiring apprentices or trainees down the track. So that's all from me in terms of Liberal policies. I will now pass the floor to Karina, who will take us through a case study.
Thanks, Jen. Good afternoon, everyone. My name is Karina. I'm a law graduate who recently started with the Employment Relations team here at MST. So to close out today's webinar, we've just prepared a short case study of a recent decision handed down by the full bench of the Fair Work Commission. Whilst it's not related directly to election policies, this decision serves to highlight the complexities of employment legislation and the impact that failures to follow proper procedures may have on employers, with a particular focus on how to respond to requests for flexible work arrangements. The applicant in this case was Miss Naden, a classroom teacher at a primary school in New South Wales. She had been employed since 2016, but in 2023, the school promoted her to an executive role as the Religious Education Coordinator. This executive role involved a number of additional responsibilities, but also carried with it additional remuneration. In 2024, Ms. Naden took parental leave to accommodate the birth of her child. To balance her new parental responsibilities and her work commitments, she made a request to return as a part-time employee during term 1 and 2 of the 2025 school year. She also proposed that she would return to full-time work at the start of term 3 of this year. Whilst there was some negotiation between Ms. Naden and the school, ultimately the parties could not come to an agreement. The school was reluctant to allow a teacher with executive responsibilities to work part-time. They proposed instead that they allow her to return to a part-time teaching role, but would not allow her to return to the RE coordinator role until she returned to full-time work. If we could just head to the next slide, please. Thanks, Dina. By way of context, flexible working arrangements are a minimum standard which applies under the National Employment Standards. If an employee meets the circumstances and service requirements as set out under the Fair Work Act, they may make a written request for flexible working arrangements to accommodate these circumstances. Some examples of this may include employees who are pregnant, employees who have a disability, those who are suffering from family and domestic violence, or just like in this case, employees who are the parents of children who are school age or younger. The NES also provides guidelines to employers about your obligations to responding to requests for flexible working arrangements. A simplified version of these requirements is set out on the slide, but in essence, an employer must provide a written response within 21 days of receiving the initial request. There are additional rules about what must be contained within the response, and these change depending on if you intend to agree with the flexible work arrangement or if you would like to make proposed adjustments or to refuse the request. In the event that the employer wishes to refuse a request, you also have additional requirements, namely discussing the request with the employee and genuinely trying to reach an agreement with them in order to accommodate their circumstances. But in the event that you're unable to reach an agreement, the employer must have considered the consequences of the refusal for the employee, and also ensure that the refusal is due to reasonable business grounds. So all of these points must be explained and included within the employer's written response. Coming back to the case study now, I'll just jump to, thank you. Coming back to the case study, Ms. Naden provided evidence that the refusal of her proposed changes would have had negative financial impacts on her and her family, given the loss of pay associated with not performing the RE coordinator role. Additionally, there was also evidence suggesting that the refusal would place her at a disadvantage for future career advancement. The school failed to provide evidence that any of these concerns were discussed or considered when they were refusing the request. So, in addition to the fact that there was an extensive delay of 82 days to provide the written response, the Fair Work Commission found that the employer had failed to meet the requirements needed to validly refuse a request. So this meant that even though they may have had reasonable business grounds for refusing, they were not entitled to, as they hadn't met all the consultation requirements within the Act. The case clearly illustrates that legislation surrounding workplace relations and management can often be complex and unintuitive. So doubling back to, I think, what my colleagues have said earlier, regardless of who wins on Saturday, there's inevitably going to be new questions and complexities that arise. And so it doesn't hurt to be prepared for any eventuality. I think I'll pass back to James, who will just have a quick discussion about, what you as employers might be able to do to be more prepared for any upcoming changes.
Thank you, Karina, and thank you for that case study, a timely reminder of the additional obligations placed on employers for flexible work arrangements that came in the government's current term. Dean, if we could go to the next slide, please. You've heard a lot of information today about what policies may or may not come into effect, how that may affect your business, and what you may need to do moving forward. And the simple answer is, without a crystal ball, that is all up in the air until Saturday night, when we find out who is successful. But there is a 4-step plan that we think all employers as of next week should be taking. The first one is, in light of all of the changes that came into effect this year, have a review of all of your contracts, employment agreements, and how you classify people you engage, casuals, contractor, labour hire. Make sure we've complied with all of those changes. Then let's consider what is going to change moving forward and what changes we need to make to those. Second is to update your workplace policies. If we get a number of changes because the Liberal Party is successful, there's going to be some policies that you need to update. The policies, of course, are the rules under which employees must operate within your business. But we need to have them right. The third step is keep an eye on any changes that are coming in the future. There is a good chance that in the next 12 to 24 months, we are going to have a number of changes, irrespective of which party is successful, and we need to monitor them. We will continue to send out, as we always do, newsletters updating you of those changes, but it never hurts to reach out to us to just check in. Have your employment agreements reviewed each year, and we'll keep you abreast of those changes. And finally, come and speak to us, as I said. You're welcome to reach out to your usual contact here at MST in any team, and they'll put you on to the appropriate person here in the employment law team, or to one of us who've presented today to ask any questions or reach out for any assistance that you may need. Other than that, that's our presentation for today. Are there any questions from anyone about what we might expect on Saturday, what changes could be coming, or any other areas of employment law that you may have concerns in?
Well, just to reinforce what James just said, first of all, guys, great presentations. Thank you very much. Our chat box is a little quiet, if I'm reading it correctly. So please feel free to unmute yourself and ask a question. I have a question, actually, if I can start the ball rolling. If we do have an Albanese government returned on Saturday, which appears likely, and assuming the Greens get their way and casuals are provided annual and personal leave entitlements, noting that they already receive benefits under the long service leave laws, noting that they share similar protections to permanent staff in relation to unfair dismissal protection and general protections and discrimination generally, the question has to be asked, what's the benefit in employing a casual versus a permanent part-timer?
Yeah, very good question. The answer is very quickly heading towards not a lot. We are, and have been for the entirety of this current government, been facing a push towards permanent ongoing employment. The first amending act was the Secure Jobs Better Pay Act. And there's no hiding that that's what we're looking for, or what the Labor Party is looking for in their governing, push towards permanent employment and away from casual and labour hire. We might find ourselves in a scenario where the benefits of casual simply are no longer available, or they no longer exist, and you will look to fill your business with full-time, part-time, and then reach out to labour hire providers to provide that last-minute shift worker that you require, particularly in industries where there is transferable skills. And you might find new businesses open up who provide labour hire in industries that otherwise wouldn't normally have been labour hire industries if casuals are no longer a benefit to business.
Right, thank you. And that, if I could just follow up quickly, we've seen this morning in the media the suggestion about portable long service leave schemes being extended to casuals. Thoughts? That's a bit heavy to hit you with that, given it's just come out of the media, but I thought I'd hit you with it anyway.
No, absolutely. So for those of you who haven't read the front of the Australian today, the industry groups are concerned that the unions are going to press for portable long service leave across the country. And so it's not just going to be casuals, it's going to be a large portion of the employees in this country, which is going to result in an estimated $19 billion hole in the economy, and also a $900 million cash cow for unions, keeping in mind that IncoLink and these portable long service leave schemes that exist are run by and handled by unions. And so employers, instead of having long service leave money sitting in their bank account to be used for operating businesses, that money will need to be paid on an ongoing basis to a portable long service leave scheme, which is then managed by a union body. And ultimately, the money is then not available to employers to use to run their business. Also keeping in mind that employees aren't entitled to long service leave until they reach the period of employment with an employer. So often, particularly in this, this day and age where a long-standing employee can be considered someone who's only been there 4 years, given the rate at which people move, a lot of employees aren't able to get long service leave because they don't stick around. And then it's a cost the business doesn't have to incur. But if this change was to come in, it would mean that businesses would be paying long service leave from day one for every employee into a fund which they have no control over.
I haven't seen anybody raising any questions.
Sorry, Herb, can I ask a quick question?
Siobhan.
From, yes.
How are you, Siobhan?
Really well, thanks. And you? Herb, in our situation, we have no choice but to employ casual staff. I think our workforce, probably 95% of our workforce is casual. How do you see that impacting us?
Look, I think in your case, Siobhan, and without sort of disclosing to the whole audience the industry in which you work, but there will still be a case for casual staff, certainly industry specific, and I think yours is a good example of that.
Yes.
So it won't obviate the need or the benefit in using casuals moving forward. They just become less appealing because of the additional cost involved in having to pay annual and personal leave.
Yes.
Again, there's a lot of unknowns. Will the 25% casual loading be retained, notwithstanding the introduction of those paid entitlements? As James has indicated, a good chunk of that 25% relates to annual and personal leave costs. So, will there be an adjustment down in the loading? Who knows? So,
yeah.
In short, to answer your question, I still think there is a need for the use of casual labour moving forward. It just becomes less appealing to a lot of industries. Probably the best way of answering it.
Okay.
We have got one question, Herb, that's come in.
Yeah.
Fire away.
It's a question from Kathleen. Thank you very much, Kathleen. Is there anything that may impact employees with disabilities, e.g. employed under supported employment services? There's nothing on the horizon that's been clearly articulated by either party. There is currently the SHADS award being reviewed, which may ultimately have an effect on those employees who assist. But from an employer's point of view, supported employment services aren't on the agenda for either major political party at this stage.
Great. Thank you, James. And thank you, Kathleen, for that question. I have one last question, if I could throw it to the group. The right to disconnect, it drew immense media attention, as we all know, when it was in the course of last year. But I think there's a misconception about actually what does it mean? Does it prevent? I think the misconception centrally is it seeks to prevent employers from reaching out to employees outside their normal working hours. Could you perhaps clarify that and throw some water on that, perhaps, for the benefit of our audience?
Yeah, absolutely. So the right to disconnect actually comes in realistically 2 stages. The first is the employee actually has to enact that right, and that is they have to refuse contact outside of working hours. Until the employee has done so, there is nothing preventing employers from reaching out to employees outside of work hours. The second step is then, once that employee has made that request, the question becomes, is that request or the request to not be contacted or the right to be disconnected reasonable? And ultimately, it ends up at the Fair Work Commission to have a discussion if no one can agree. Realistically, as long as an employee asks that question, employers should enter into negotiations or discussions with them as to what it is they're after, why, and when can they be contacted. The Fair Work Act sets out a range of criteria to consider whether contact is reasonable and whether a refusal is unreasonable, things like what an employee's salary is, the type of job they do, the industry they work in. It would be shooting themselves in the foot as an employee, particularly a casual, if they asked not to be contacted outside of their hours when all that the employer wanted to do was ask if they wanted to do a shift at the next day. So it doesn't abolish the ability for you to just reach out and contact staff, particularly if they haven't asked you to not contact them. It's simply a limitation on unreasonable communications outside of hours. For example, phone calls at 11 p.m. on a Saturday because something has occurred that can realistically wait until Monday. So it's not a black and white, you cannot contact. There's a lot of discussion area in there.
Fantastic. Great. Thank you, James. All right. Well, given the time, it's we're bang on 1:30. So I look, unless there are any other questions from the audience, again, I want to thank James, Jen and Karina for their contributions today. Fantastic presentations from each of you. Thank you again. I want to thank the audience also for taking time out of their day to sit in and participate in today's session. If you have any questions or feedback post this webinar, please do not, as James has indicated, please do not hesitate to contact any one of us, any one of the presenters, or anyone indeed that you deal with traditionally in MST or feedback to us. We'll be delighted to answer any questions or feedback that you may have. I assume a copy of these slides will be available. We'll be setting out, I'm sure. Dina's nodding her head profusely because she's across all this, of course. The slides will be sent out post now. Really nothing else to do, but thank you again for your time, and take care and have a wonderful rest of the day.